Aslamo.alakam. And welcome back to our channel, True Courtroom Stories. Before we really get started today, just a quick reminder for everyone listening, if you appreciate the work we do here, kindly subscribe to our channel, like this video, and maybe share it with friends who you think would find it interesting. It makes a huge difference. All right. So, for today's session, we are diving deep into what's been labeled episode 117 of True Courtroom Stories. And this is all based on the really incredible research compiled by Mr. Zahir Ahmad Mir. And the topic we're tackling is, well, it's absolutely fundamental. It's the protection against arbitrary arrest.
It really is. This isn't some, dry legal technicality.
Yeah, not at all.
This is the line in the sand. It defines the relationship between the individual and the state. It's about how much power the government can have over your actual physical body.
Exactly. It tells you whether you live in a free society or, to put it bluntly, a police state.
And what's so compelling about the sources Mr. Mir has put together here is that they don't just throw legal articles at you. They start with the philosophical foundation, the ratio, as it's called.
The why.
The why behind all the laws. And it's a powerful one.
Okay, let's not wait then. Let's get right into it. What is that central idea, that philosophical anchor for this whole deep dive?
The core principle, the ratio that everything else we'll discuss builds upon, is this. Liberty cannot be hostage to suspicion.
That wording is so deliberate. Hostage.
It is.
It's not just liberty cannot be taken by suspicion. The word hostage implies a kind of violent, illegitimate seizure. It paints a picture of your freedom being held for ransom.
That's precisely the point. It frames the conversation correctly. It highlights this constant, this permanent tension that exists in any society.
A tension between what, exactly?
Between the state's need to function, to investigate crimes, to maintain order, and the individual's absolute fundamental right to be free.
And that's a delicate balance.
It's an incredibly delicate balance. The state, of course, needs to be able to look into things. But the principle here says it cannot just seize a person, hold them indefinitely based on
what?
A hunch.
A feeling.
A feeling, an official's gut instinct, maybe even a prejudice. None of that is enough.
So if we follow that hostage metaphor, the suspicion is the weak currency used to seize this incredibly valuable thing, your freedom.
That's the core of the analysis, yes. Because suspicion is, by its very nature, subjective. It exists entirely inside the mind of an investigator or an officer.
Right. It's not a fact you can point to.
It's not. It can be manipulated, it can be based on bad information, it can be wrong. And to allow something so flimsy to justify something so profound as taking away someone's liberty, well, that's where the system has to draw the line.
And that brings us to the key term here, arbitrary. When we say arbitrary arrest, what does that mean in a functional legal sense?
It means an arrest made without a proper legal basis, without following a set, established procedure, or, and this is the crucial part, without an objective justification that meets a certain legally defined threshold.
Okay, so it's not just about the reason, but also the method.
Exactly. When the state wants to detain you, it has to be able to do two things. One, point to a specific law you've supposedly broken. And two, point to a specific set of facts or evidence that makes that law apply to you.
And if they can't?
If they can only say, well, we suspect him, or it feels wrong, then the action is arbitrary. It's based on a whim. And in that moment, the person becomes the very hostage that the ratio warns us against.
Now, what I find fascinating about the structure of these sources is the sheer scope. We're not just looking at one country's laws.
No, it's much broader.
Mr. Mir's research takes us on a journey, really, from historical Islamic legal principles to a global standard like habeas corpus, and then it brings it all home to a specific constitutional framework. In this case, Pakistan's Articles 9 and 10.
And that structure is so important. What it does is show the lineage of this right. It demonstrates its universality.
It's not a modern Western invention.
Not at all. The idea that the state can't just snatch you off the street without a very good objective reason is a principle that echoes across centuries, across faiths, across legal traditions. It's a common thread in the pursuit of justice.
So our mission for this deep dive, then, is to move past that philosophy and find the practical tools, the shields, if you will.
The mechanism.
The mechanisms. We want to understand how these different legal systems actually manage that tension we talked about. How do they protect people from being locked up based on nothing more than a feeling in an official's gut?
We're looking for how that powerful idea, liberty is not a hostage, gets turned into a real, practical, enforceable right that you can actually use.
Okay. Let's stay with that philosophical anchor for a moment because it's just so powerful. Liberty cannot be hostage to suspicion. Let's really dig into that. Because the counterargument is always about public safety, right? The state will say, look, to prevent crime, we need the power to detain people who seem suspicious. Why is that a dangerous path?
It's the essential question, isn't it? It's the trade-off. And the reason that path is so dangerous is that giving the state the power to deprive liberty based on mere suspicion is like handing the executive branch a blank check.
A blank check for what?
A blank check to control people's lives without accountability. Think about it. Suspicion is, as we said, subjective. It's fleeting. It can be driven by bias, by bad intel, by political pressure.
And liberty, once it's taken away, even for a day.
The damage is immediate and real. You lose your job, your reputation is harmed, there's psychological trauma. The law insists on objectivity on proof because the right that's being taken away is at the highest possible value. The cost of getting it wrong is just too high.
So, if a system allows suspicion to be enough for detention, does that change how police work is done? Does it, for example, make investigations lazy?
It absolutely short-circuits the entire justice system. It creates terrible incentives.
How so?
Well, if an officer can arrest you simply because they suspect you, they no longer have to do the hard work. The difficult, time-consuming, expensive work of gathering actual evidence.
Like surveillance, finding witnesses.
All of it. They can skip that vital step that takes you from a mere suspicion to what the law requires, which is probable cause.
And that's a critical distinction. Let's define that. What's the difference?
It's a world of difference. Suspicion is just a hunch. Probable cause, on the other hand, requires objective, articulable facts. Facts that would lead a reasonable person to believe two things. One, that a crime has been committed, and two, that the person being arrested is the one who committed it.
It has to be something you can explain to a judge.
You have to be able to lay it out on the table. Suspicion requires none of that. It turns the legal system from one based on verifiable fact into one based on official intuition.
Or worse, official convenience.
Exactly. And consider the danger there. If the police can hold you for 24 hours on a hunch, why not 48? Why not a week? Why not a month? All under the excuse that their suspicion hasn't been satisfied yet.
So the detention itself becomes the investigation tool.
Precisely. The purpose shifts. It's
Yeah.
no longer about holding a person for a trial that's based on existing evidence. It's about using the detention, the isolation, the pressure to generate the evidence they should have had in the first place.
That's the hostage situation.
That is the hostage situation. You're being held not because of what you've done, but because of the state's desire to find something out.
So this principle isn't just about protecting individuals who might be innocent. It sounds like it's about protecting the integrity of the whole legal system, the rule of law itself.
It's the absolute bedrock. The rule of law demands predictability. It demands accountability.
Right. You need to know what the rules are.
You have to be able to understand what actions will lead to the state intervening in your life. If that intervention can be triggered by something as vague and shifting as an official suspicion, predictability just vanishes.
And accountability.
How do you hold the state accountable for a suspicion? It's almost impossible to challenge in court. How do you cross-examine a feeling?
You can't.
You can't.
Yeah.
So when suspicion is allowed to trump liberty, fear replaces procedure, and your system of law collapses into just a system of arbitrary authority. It's about who has the power, not what the law says.
This really sets the stage perfectly for the mechanisms we're about to get into. All these legal tools we're going to discuss, they're essentially the barriers, the roadblocks.
The objective roadblocks.
Placed between that subjective feeling of suspicion and the citizen's fundamental right to just walk free.
They're designed to translate that moral imperative, don't take people hostage, into mandatory practical legal steps. And it's a very old struggle, which is why the sources compiled by Mr. Muir take us back in time first.
Okay, let's go there. When we look at the historical roots of these safeguards, the source material points us first to a core Islamic principle: no detention without proof.
Yes, and this is so important because it shows this isn't a new idea. This requirement for evidence-based action is deeply rooted in a legal tradition that predates many of the constitutional documents we might be more familiar with.
It establishes what we now recognize globally as the presumption of innocence.
It does. It's one of the earliest and most robust constraints on the power of the state when it comes to a person's physical freedom.
So what's the central legal maxim that guides this principle?
The core concept is bara al-dima,
Okay.
and that essentially translates to the presumption of innocence. It establishes the default legal status of any individual. You are considered innocent until and only unless you are definitively proven otherwise.
That sounds simple, but it's actually revolutionary in how it distributes power, isn't it?
Completely. It flips the script. It places the burden of proof firmly, squarely, and heavily on the accuser, whether that's another individual or, more importantly for our discussion, the state.
So you don't have to prove you're innocent.
You don't have to prove a negative. The state has to prove you are guilty. They have to come to the table with their case already built.
That seems like a massive hurdle for the state to clear before they can even think about detaining someone.
It is, and it's meant to be. This connects directly to the concept of bayina.
Which means proof.
It's often translated as proof, but it's a bit more than that. It implies clear, verifiable, objective evidence that meets a very high standard. It's the opposite of rumor or conjecture or, of course, mere suspicion.
So what would qualify as bayina in practice? What did this objective proof actually look like?
It depended on the matter, but for criminal cases where liberty was at stake, the standard was incredibly high. It was about achieving certainty or something very close to it.
For instance,
It might require multiple credible eyewitnesses, and not just any witnesses. There were often standards for their reliability and moral character.
so you couldn't just grab someone off the street to be a witness?
No, their testimony had to have weight. Or, another example would be an uncoerced confession, freely given.
Hmm.
Or clear, undeniable physical evidence, what might be called Qarain.
The key distinction here, it seems, is verifiability.
That's the word. The evidence had to be objective and verifiable, something that could be examined and tested. Suspicion, again, is verifiable really by asking the person who holds it. It's a dead end.
So the system essentially says to the state, you can be as suspicious as you like about that person, but your feelings are irrelevant to us. Do you have two reliable witnesses? Do you have the stolen item in their hand?
If not, you cannot touch their liberty. That is the core constraint.
And what about when detention was authorized? Let's say the state met that high bar of proof. What was the purpose of that pretrial detention?
This is also crucial. It was never meant to be a punishment.
Right, the trial hasn't happened yet.
Exactly. The detention was strictly for a few limited practical necessities. The purpose had to be clearly defined.
And what were those acceptable reasons?
They were all focused on the smooth administration of justice. For example, to prevent a person who is credibly accused from fleeing the jurisdiction before their trial,
A flight risk.
a flight risk, or to prevent them from tampering with evidence or intimidating key witnesses, or in some cases, to ensure public safety if the person posed an immediate and ongoing threat.
But even then,
Even then, the detention had to be as brief as possible. It was a temporary measure to solve a specific logistical problem for the court, not an opportunity for the state to continue its investigation.
so if the state couldn't point to one of those specific reasons
Mhm.
and connect it to their initial proof, the detention was invalid.
Correct. No matter how convinced they were of the person's guilt, the system was designed with a deep, powerful opposition to indefinite investigative detention.
Which is what happens when you arrest someone first and then look for the evidence.
The exact practice these principles were designed to block, because that is the epitome of arbitrary power.
Let's connect this all back to the bigger philosophical idea. Why was this principle of innocence, this high bar for proof, so central? You mentioned it relates to human dignity.
Absolutely.
Mm.
Because in this jurisprudential tradition, liberty and personal dignity karama are not rights that the state gives you.
They're inherent.
They are inherent rights granted by the Creator. The state is merely a steward, a trustee of those rights. It doesn't own them, and therefore it cannot infringe upon them lightly or on a whim.
So to allow detention based on suspicion would be a violation of that trust.
A fundamental violation of that divine trust and the inherent dignity of every single person. The state is constrained by a moral duty to treat you as a rights-bearing individual, not just an object of its investigation.
That creates such a powerful historical precedent, a moral precedent. The idea that you need objective high-bar proof before you can take someone's freedom is set as a universal standard for justice.
It is, and that standard, that ancient demand for verifiable evidence, leads us directly to the modern procedural tools designed to enforce that very same idea.
So we've established the ancient why, this moral and legal demand for proof. Now our sources guide us to pivot to the global procedural how,
The enforcement mechanism.
the enforcement mechanism, the writ of habeas corpus. Many people have heard the term, but they might not know exactly what it means. It's often called the single most important legal instrument for protecting liberty ever devised.
And for good reason. It is the legal engine that makes the philosophy real. It takes that demand for proof and turns it into a command for justification from the state.
Let's start with a clear, simple definition. What does habeas corpus literally mean, and what does it do?
Okay, so the Latin habeas corpus literally means you shall have the body.
Have the body.
Yes, it's a formal court order, a writ issued by a judge, and it's directed at whoever is holding a person in custody, the jailer, the police chief, a military commander.
And what does it command them to do?
Two things. First, it commands them to physically bring the detained person, the body, before the court at a specific time and place. And second, at that same moment, they must provide the legal grounds, the complete justification for why they are holding that person.
So the judge isn't conducting a full trial at that moment.
Not at all.
They're asking one very simple, very direct question. Is this detention lawful, yes or no?
That's it, exactly. It is a procedural challenge to the state's power to seize a person. The judge looks at the justification provided by the state. Is there a valid warrant? Is there a specific charge sheet? Is there a clear law that allows for this detention?
And if the state comes up empty-handed?
If the state cannot provide a satisfactory legal basis, the court has no choice. It must order the immediate and unconditional release of the detainee. It essentially forces the state to open its books and show its work.
The sources link the origins of this idea, at least in spirit, back to the Magna Carta in 1215. Can you walk us through that connection?
It's a crucial lineage. The formal writ of habeas corpus evolved over many centuries in English common law, but its conceptual roots are definitely in that early push to limit the absolute power of the monarch.
The idea that even the king is not above the law.
Precisely. Clause 39 of the Magna Carta is the famous one. It said that no free man could be imprisoned or have his property taken except by the lawful judgment of his peers or by the law of the land.
By the law of the land. There's that phrase again.
There it is. It was this revolutionary first step establishing that power had to follow a known procedure. It couldn't just be arbitrary. Habeas corpus, then, is the ultimate judicial tool designed to enforce that very principle. It is the legal weapon you use to challenge a detention that is not by the law of the land.
So this represents a massive power shift. It yanks power away from the executive branch, the police, the army, the people who do the arresting, and puts it squarely in the hands of the judiciary.
That is its critical political function. The moment a lawyer files a habeas corpus petition, the executive branch is put on the defensive.
They're on the clock.
They're on the clock, and they have to justify their use of force to an independent judge. This separation of powers is the cornerstone of preventing tyranny. If the police could just arrest and hold people without ever having to answer to a court, then the no detention without proof rule would be meaningless. It would just be words on paper.
Habeas corpus makes it real.
It makes it a living reality.
But let me push back a bit here, introduce some friction. We know from history that governments can and do suspend the writ of habeas corpus, usually in times of war or national emergency. Doesn't that fragility undermine the whole idea that this is some universal guarantee?
That's a powerful and very necessary question. But I would argue the opposite. The very fact that governments feel they have to formally suspend the writ actually proves how powerful it is.
How so?
When a government wants to start arresting people without justification, they know what's standing in their way. It's habeas corpus. So the act of suspending it is an admission. Is the government publicly saying we are about to engage in arbitrary detention and this legal tool is the only thing stopping us, so we have to disable it first?
So the suspension is the exception that proves the rule.
Exactly. The temporary victory of unchecked power. But the existence of the writ, the ideal itself, remains the benchmark for liberty. It's the standard to which things must eventually return. So yes, it's fragile, but its existence is what defines a free society.
Let's use a clear, practical example to show how this works, a hypothetical scenario.
Okay, let's imagine a political activist, we'll call her Mrs. B, is arrested during a protest. The police take her away, and for 2 days, her family and lawyer hear nothing.
Incommunicado.
Incommunicado. When her lawyer finally gets a hold of an officer, they're told she's under investigation for internal security matters. No charge, no details.
A classic fishing expedition.
A classic case. So the lawyer immediately goes to a judge and files a petition for a writ of habeas corpus. The judge issues the writ and orders the police to present Mrs. B in court the next morning, along with their legal justification.
So the very next day, the state has to answer.
The very next day. The police show up. They bring Mrs. B. The judge asks, on what grounds are you holding this woman? And the police say, well, Your Honor, we suspect her of incitement, but we don't have a formal charge sheet yet. We're still gathering evidence.
And what does the judge do?
The judge looks at the lot and says, suspicion is not grounds for detention. You have no charge. You have no warrant. This detention is arbitrary. Release her immediately.
And the police have to comply.
They have no choice. The judicial order is binding. And the key thing here is how habeas corpus just cuts through all the bureaucratic excuses, all the investigative delays. It forces an immediate check based on one thing and one thing only: the legality of the detention right now.
It's that immediate judicial intervention. That's the power. It ensures the state can't just make someone disappear into the system while they try to build a case.
It is the ultimate procedural shield against being held hostage to suspicion.
Okay, so we've traced this right from an ancient moral demand for proof all the way to this global procedural check of judicial review. Now, the sources bring us to the final piece: how these universal ideas get written down, codified, and made actionable in a specific country's constitution.
Yes, in this case, the Constitution of Pakistan, and specifically through Articles 9 and 10.
And this part is so important because this is where abstract principles become concrete, enforceable rights for citizens.
Exactly. These two articles work together to provide a kind of layered defense. They translate that core ratio liberty is not a hostage into specific time-bound legal actions.
Let's start with Article 9. It establishes the foundational right to security of person.
That's right. Article 9 is the broad philosophical guarantee. It states, and the wording is critical, no person shall be deprived of life or liberty save in accordance with law.
Save in accordance with law. We've heard a version of that phrase before from the Magna Carta. It sounds so simple, but I'm guessing the legal weight is immense.
It is the single most important phrase for procedural fairness. In accordance with law means two things at once.
Okay.
First, that any action that takes away your liberty must be authorized by an actual specific law that's been passed by the legislature, not just a random government decree.
So there has to be a pre-existing rule.
Yes, but second, and this is even more important, the process they use to deprive you of that liberty must strictly follow the established fair procedures laid out in that law.
So any deviation from the rulebook makes the detention illegal.
Any deviation, no matter how guilty the police think you are, if they don't follow the procedure, the detention is not in accordance with law and is therefore, by definition, arbitrary. It mandates transparency, fairness, and accountability at every single step.
So Article 9 is the big promise, the guarantee.
Yeah.
But it's Article 10 that gives you the tools to hold the state to that promise.
That's a perfect way to put it. Article 10 is the operational manual. It's the practical shield. It details the rights that kick in the very moment you are arrested to make sure that the vulnerability of that situation isn't abused.
It's the rulebook the state has to follow.
It is, and we really need to break down its main clauses because these are the gears of the machine that protects liberty.
All right, let's start with the first protection. It's about knowledge, about transparency.
It is. It's the right to be informed of the grounds for your arrest. Article 10 says that no person who is arrested can be detained without being told, and I quote, as soon as may be, why they are being arrested.
That phrase, as soon as may be, what does that mean in practice? Not necessarily the second they put the cuffs on.
Not necessarily that exact second, but it means without any unreasonable delay, without deliberate obfuscation. It has to be prompt.
And why is that initial transparency so critical for preventing arbitrary action?
Because it kills the fishing expedition we talked about earlier. It stops the state from just grabbing someone on a whim and then trying to figure out a charge later.
They have to have their stories straight from the beginning.
They have to have already made a preliminary justifiable legal decision before making the arrest. It also means the person who's been arrested, or their lawyer, can start preparing a defense right away. The grounds have to be specific. Just saying, you're under investigation isn't enough. It's the first check on that subjective suspicion.
Okay, so first you have the right to know why you're there. What's the second safeguard?
The second addresses the huge power imbalance that exists in that moment. It's the right to counsel.
The right to a lawyer.
The right to consult and be defended by a legal practitioner of your own choice. This is about ensuring your rights are protected when you are at your most vulnerable.
The lawyer acts as a watchdog.
An immediate check on potential abuse. They're there to make sure your rights, like the right to remain silent, the protection against a coerced confession, are respected from the very first minute. It prevents you from having to face the immense power of the state all alone.
And now we get to what the sources really emphasize as the most crucial, the most practical mechanism, the absolute deadline.
Yes. The shield against being disappeared into the system, the production before a magistrate.
And this is where the clock starts ticking.
This is the most direct, practical application of the spirit of habeas corpus within the Constitution. It sets a hard, non-negotiable limit on the executive's power. Article 10 demands that every person arrested must be produced before the nearest magistrate within 24 hours of that arrest.
24 hours, that is a very tight deadline.
It's incredibly tight, and it's meant to be. The only exception is the actual time it takes to travel from the place of arrest to the court.
So why is that 24-hour limit the key? What specific abuses does that strict clock prevent?
Its importance really cannot be overstated. It's the constitutional tripwire. First, it forces immediate judicial oversight. It says the police, the executive branch, can only hold you on their own authority for a maximum of 24 hours. After that, their power runs out. The matter must be handed over to the judiciary. They can't just decide to hold you longer. They have to ask a judge for permission.
Oh, remand.
A remand. Second, it's a powerful preventative against coercion and torture. The ideal conditions for abuse are prolonged, incommunicado detention. By putting a hard 24-hour deadline on that, the Constitution shrinks the window for illegal interrogation methods.
And third.
Third, it kills suspicion as a valid reason for continued detention. When the police bring you before the magistrate, they have to present their case. If they have probable cause, if they have evidence, they can ask for a remand. But if all they have is, well, Your Honor, we're still suspicious, the magistrate's duty is to order your release. It is the enforcement of the no detention without proof rule.
So if that 24-hour clock runs out and the police haven't produced you in court, the detention becomes illegal.
Instantly and fundamentally illegal. It becomes ultra vires beyond their legal powers. This underlines that the legality of a detention is just as much about how you are held as why you are held. If the procedure is broken, the entire detention collapses, even if the person might actually be guilty.
The state cannot bypass the clock.
The state must respect the clock.
Let's run a quick scenario here, too. Imagine a case where this mechanism is tested to really show what's at stake.
Okay. Imagine a high-profile case. The authorities arrest someone they strongly believe is a key conspirator in a major plot. But the evidence is thin, and they think they need 48 hours of intense questioning to get what they need.
So they decide to bend the rules.
They decide to ignore the 24-hour clock. Maybe they hold the person in an undisclosed location, or they try to argue the clock didn't start until they formally book them at the station hours after the actual arrest.
So 48, 72 hours go by. The family's lawyer files a habeas corpus petition.
Yes. And when that case comes before the judge's focus is singular. They don't care how important the crime is or how convinced the police are. They care about one thing: the clock.
It's procedure.
The procedure. Has this person been produced before a magistrate within 24 hours? The answer is no. And therefore, the judge must rule that the detention is arbitrary and illegal, and they must order the person's release.
Which might mean a guilty person walks free.
It might. And that illustrates the tension perfectly. The law makes a choice. It prioritizes liberty and due process over the convenience of an investigation. It says the state must win by the rules, or it doesn't win at all.
So taken together, Articles 9 and 10 create this comprehensive layered shield.
Exactly. Article 9 is the big philosophical promise of security. And Article 10 provides the nuts and bolts, the right to know, the right to a lawyer, and that critical 24-hour clock that ensure the executive branch is always accountable to the law and to the judiciary. It's the ultimate practical defense against the state holding its own citizens hostage.
So this entire deep dive, drawing from Mr. Zahir Ahmad Mir's work in episode 117, has really painted a complete picture for us. We've traced this fundamental right from an ancient philosophical idea all the way down to a very specific, time-bound procedural rule.
We really have. We've uncovered what are essentially three indispensable layers of protection that have to exist in any system that truly values individual freedom.
Let's recap them. What was the first layer?
The first was that ancient moral requirement for proof. The presumption of innocence, Bard al-Dima, which establishes that a state's objective suspicion is never, ever enough to justify the objective loss of a person's liberty.
And the second layer?
The second was the procedural global check of habeas corpus. This is the judicial mechanism, the tool that empowers an independent court to step in immediately and force the executive to justify, with legal cause, why it has seized a person's body.
And finally, the third layer brings it all into modern law.
The third is the specific constitutional codification we see in things like Articles 9 and 10. These articles take that general idea of judicial oversight and make it compulsory, non-negotiable, and time-bound, most critically through that 24-hour judicial production rule.
So we come full circle, right back to that core ratio.
Yeah.
Any system that claims to be based on the rule of law has to start from the idea that the state bears the burden of justifying its actions.
Yes. And that mere suspicion is, by design, structurally insufficient to meet that burden. The law is supposed to be a heavy shield against the state's natural tendency to overreach.
This analysis gives us a fantastic understanding of how the law is supposed to work.
It does. But, understanding the design of the shield is one thing. Ensuring it's strong enough to withstand real-world pressures.
Yeah.
That's another matter entirely.
And I think that leads us perfectly into our final provocative thought for you, the listener, to consider based on everything we've just discussed. If we agree that the ultimate practical defense against arbitrary arrest is that strict judicial check, that magistrate demanding a valid reason within 24 hours, then what happens to our liberty when the courts themselves are weakened?
That is the frightening question, isn't it? If the judiciary, for whatever reason, lacks the resources or the independence or just the sheer institutional willpower to enforce that 24-hour clock with absolute rigor.
If the magistrate is overwhelmed with cases or delayed or, maybe even unwilling to challenge the police in a high-profile case,
Then the entire shield of protection doesn't just get a little weaker. It doesn't just erode slowly.
it shatters.
It collapses instantly, the mechanism fails, and all those other rights become just words on a page.
So the strength of your fundamental right to liberty is, in the end, only as strong as the judiciary's ability and willingness to enforce that clock.
When that procedure fails, the individual is right back where we started this whole discussion, a hostage to suspicion.
That practical fragility, the fact that these grand rights depend on the day-to-day functioning of an often overburdened court system, that's a sobering thought.
It is. And it's the ultimate takeaway. It's a reminder that these rights are not self-executing. They require constant vigilance, not just from lawyers and judges, but from all of us.
A truly critical point to end on. Thank you for walking us through this essential analysis of liberty, law, and the boundaries that are meant to keep state power in check. And of course, thank you for taking this deep dive with us. We hope you continue to explore these complex topics and support the research that makes these insights possible. We'll see you next time.